Hello everyone, my name's Josh Lewison. I'm a barrister specialising in private client and insolvency. I'm back on the roof of Radcliffe Chambers to talk about what happens when a spouse or child is omitted from a will. I'll look at the different approaches in England and Wales and California and tell you about a case that's going to be in the news over the next few months. Now, I had a case a few years ago now where the deceased left a will that he'd executed in the late 1980s. He was a young man then and single, so he appointed his father as executor and left his estate to his mother. In the nearly 40 years that followed, he lived a full life. By the time of his death, he had 4 children out of 2 relationships, 2 of whom were adults and 2 of whom were minors. He had never married, and at the time of his death, he was said to be cohabiting with a 3rd woman. What he left behind was a will that made no provision for any of these people, which led to the issue of 5 claims under the 1975 Act. And they fell into 3 groups, 1 for the adult children, 1 for the minor children, and 1 for the alleged cohabitee. The limitations of the 1975 Act are well known. First, it affords only a discretionary remedy, and where there's discretion, there's uncertainty. It makes it hard to advise your client, particularly where, as in my case, their claim was competing with a claim by adult children. And the Supreme Court did really nothing to provide any clarity as the approach the court should take when considering claims by adult children who are in sound physical and mental health. Second, children only get maintenance, and that's what's reasonable for their needs. There's no concept of getting anything more than that. That can often make claims harder to resolve because it incentivizes claimants to put together a shopping list of pipe dreams full of inflated figures. Third, spouses get the benefit of the so-called divorce cross-check, so the court will look at what they have got on a divorce. But again, that's not quite satisfactory, because on a divorce the court looks at both spouses' needs. On a 75 Act claim, one spouse has no needs because they're dead. Finally, and this really came to the fore in the case that I was dealing with, the costs of litigating this can often eclipse the estate itself. In my case, there were 3 sets of costs, and the deceased was really someone who was not wealthy enough to live life in the way that he did. But there's one other important mechanism in England that protects an omitted spouse, which is the revocation of a will on marriage. So in my case, if the deceased had married any of the women with whom he'd had a relationship, his will would have been revoked, and his wife and children would have taken under an intestacy. That would have provided a more certain result for everyone, although of course still vulnerable to 75 Act claims. It's also a very blunt tool. Any kind of careful estate planning is undone. Any gifts to friends or charities will be revoked. In California, the law operates rather differently, both in relation to spouses and in relation to children. It's important to bear in mind that California does recognise freedom of testation. There's no equivalent of the 1975 Act. But there are certain provisions that apply to unintentionally omitted spouses and children. So starting with spouses, a spouse who marries the testator after the execution of all the testamentary instruments, which here means the will or irrevocable trust, that spouse gets the decedent's share of the community property, so that means all the community property, and the decedent's share of quasi-community property, so all of that too, and an intestacy share of the testator's separate property, up to a half share. So after a long marriage, that can actually be almost the whole estate. There are some exceptions though. So first, where the omission is intentional, and that intention appears from the testamentary documents. So that's freedom of testation in action. Where the decedent, this is the second one, where the decedent provided for the spouse outside the estate passing by testamentary instruments, so by an intervival gift or by a trust, again, that would be an exception to the spouse's right to claim. And thirdly, where the surviving spouse waived their entitlement, so that would usually be by way of a prenup. There's also an interesting provision in there to guard against predatory marriages. It's important to remember that even if the surviving spouse has been properly omitted, so one of the exceptions applies, they're actually still entitled to a half share of the community property and the quasi-community property, no matter what the decedent does. So that's a really key protection. Children, though, have a similar protection. So a child who's born after the execution of all the testamentary instruments gets an intestacy share. Again, there are exceptions to this. So 1, where the omission was intentional and the intention appears from the testamentary instruments. Freedom of testation again. The second is where the decedent disposed of substantially all of the estate to the parent of the omitted child. Third, whether the decedent provided for the child by transfer outside the estate. So, going back to my English case, the 4 children would each have got 25% of the estate. It's not necessarily the best result, because the minors had greater needs than the adult children, but you get there without litigation, and it's a result that's on some level fair, and that perhaps they could have lived with. California also provides protection for children who were born before the will. So where the deceased's testamentary instruments fail to provide for a child solely because the decedent believed that the child was dead or was unaware of their birth, that child is entitled to an intestacy share. And if you think that scenario sounds a bit far-fetched, I'd really recommend reading Estate of Torregano, which is a decision of the California Supreme Court with some truly remarkable facts. But the case I was going to tell you about arises out of the affairs of Steve Bing, who you may remember was a mega-wealthy film producer who died over the summer. Mr. Bing had 2 children, Damien Hurley, son of Liz Hurley, born in 2002, and Kyra, born in 1998. Mr. Bing left a will, executed in 2001, which includes a declaration, which says, "I've recently been informed by an individual that she's pregnant with my child. My intention is not to provide in this will for such child or any other child of which I may be the father." And this was an attitude that persisted for the rest of his life. Now, the clause probably refers to Damien, but there's no reference to Kyra, who was born before the will. Last summer, she and Damien won a case in which they established their right to benefit under a trust set up by Steve Bing's father. Now, she started a fresh claim to become special administrator of Steve Bing's estate in order to contest a lawsuit. Now, this may well be a prelude to an attempt to assert her rights as an omitted child. So in the coming months, we may see these interesting issues surfacing again. So first, whether the any other child language is wide enough to cover a child already born and not known about. And second, whether Kyra was omitted solely because Mr. Bing was unaware of her birth. So that promises to be quite interesting. Now, as always, when looking at different approaches in different jurisdictions, I think it's important to steer clear of the idea that there's only one right answer. In relation to succession, the right answer, if there is one, probably depends on your view as to the relative importance of freedom of testation on the one hand, and providing for family members on the other hand. On this occasion, though, I do think that California is on the right track, with its expansion of revocation to children as well as spouses, and its restriction of the effect of revocation to the provision of an intestacy share. But perhaps you take a different view. Let me know in the comments, and thanks for watching.